Most people think that if they trip and fall at a big box store or at a restaurant in Indiana, it's an automatic payday. I'm here to tell you the truth. Slip and fall cases are some of the hardest injury cases to win in this state. In fact, more of these cases fail than almost any other type of injury claim. And today I'm going to explain exactly why. Number one, no proof of hazard. The first reason cases fail is a lack of proof of the hazard. Under Indiana law, it's not enough to say that you fell. You have to prove why you fell. Was there a puddle of water, a loose rug, a broken floor tile? If you didn't take a photo of the floor immediately after you fell, or you didn't get the names of witnesses who saw the hazard, without a picture or video of the danger, the insurance company will simply say, you tripped over your own feet. And in the eyes of the law, that is a losing case. Point number two, no notice to the property owner. The second failure point is what we call notice. This is the biggest hurdle in Indiana. You have to prove the business knew or should have known that the hazard existed. If a customer spills a bottle of water and you slip on it 5 seconds later, the store isn't liable. Why? Because they didn't have a reasonable amount of time to find it and clean it up. We have to prove the spill sat there long enough for the store to know to take action, or that the puddle came from a leaking roof or a leaking refrigerator. If we can't prove the owner was negligent in their inspections, case is dead on arrival. Point number three, no medical documentation. The lack of immediate medical care. If you fall, feel embarrassed, and limp out the store saying, I'm fine, you just handed the defense their best weapon. If you wait 2 weeks to see a doctor because the pain finally became unbearable, the insurance company will argue that you got hurt at home or at work or at the gym, anywhere but their store. In Indiana, juries are skeptical. If you don't have a medical report from the day of the fall or very soon after, it's incredibly hard to link your injuries to that specific accident. Now, let's bust a huge myth. Falling does not automatically mean the property owner is responsible. Indiana is a comparative fault state. If you are looking at the phone, wearing flip-flops in the snow, or ignoring a caution sign, a jury might find you more responsible than the store. If you are 51% at fault for not watching where you're going, well, you get nothing. Now, I'm not saying any of this to discourage you. I'm saying it so you know what we're up against. Good slip and fall cases require evidence early, incident reports, photos, medical records, and witnesses. If you have those things, if the store was truly negligent and you have the proof to back it up, then these cases can be incredibly strong. But you can't wait. If you've been hurt in the fall, call us immediately so we can secure the surveillance footage before the store accidentally deletes it. Let's find out together if your case has what it takes to win. Give us a call, 317-632-3642. And remember, the insurance company is not your friend, but I can be. Give me a call.